Welcome to the Future Resolution, Miles Mediation and Arbitration's podcast. In this episode, Miles Mediation and Arbitration's very own Judge Jason Harper sits down with newly appointed Georgia Supreme Court Justice Carla Wong McMillian.
All right, we are here today with Carla Wong McMillian, who is Georgia's newest Supreme Court Justice. Carla, thank you for joining us today.
Oh, thank you for having me.
Well, Carla, I had the privilege of knowing you way back when I was a full-time state court judge. I was in the same judicial district, the 4th District, with you, and you were the Fayette County State Court Judge. I believe you were not only the first female judge in the Fayette Circuit, weren't you, and certainly the first Asian American as well. Is that right?
Yes, but at that time, I was also only the second state court judge they had in Fayette County, so it wasn't a long history there. But
yeah, you succeeded Fletcher Sams, didn't you?
Yes, and he started that court in 1997 and just did a great job, setting it up and all the processes and procedures. And I was honored to be able to follow his shoes.
Well, that is where I got to know you, and I will tell you that there are a lot of judges in the state, and you were by far one of the nicest among the state court group. For those of you listening, Carla jumped right in, and if I'm not mistaken, you even hosted our social dinners your first year in office, didn't you? You had, when we had holiday parties and things, you hosted us all in Fayette County, if my memory serves correct.
I did. Fayette happened to be the kind of a central location for our district, so I was more than happy to host the judges.
What did you do before being a judge, Carla? We all know you now mostly for being on the Court of Appeals because folks got to know you from your statewide service, but what did you do before you became a state court judge?
Well, I was a partner with the national, now international law firm of Sutherland, Asbill, and Brennan. I pretty much had been there my whole career. Right out of law school, I had clerked for Judge O'Kelly on the Northern District, but for a year, but then went to Sutherland right after that in the litigation group and did primarily franchise litigation and other business type litigation in state and federal courts around the country. I did quite a number of appeals as well, which I didn't know at the time, but would serve me well for my career. So I just had worked my way up as an associate, and then I became a partner, and really had no thought other than I would plan on staying at Sutherland the rest of my career until there was an opening that came up in my home circuit in 2010.
You mentioned that you were primarily a civil litigator. All I did when I practiced law primarily was civil and even domestic litigation. I did not aspire to be a criminal lawyer, never really wanted to be. And was it a shock to your system? Because I'll tell you it was to me. When I became judge, my first day on the bench was hearing criminal motions, which I had never even filed one before as a lawyer. And it was almost baptism by fire. The majority of what I found that we did was criminal in nature, as far as what needed hearing and trying. Did you have to get used to doing the criminal aspect of trial work in the courts?
I did. I was fortunate because I was a law clerk before that. I did work on some criminal matters when I worked with Judge O'Kelly. I mean, I remember when my year I was there, he was a senior judge and he helped out in the Middle District of Alabama. They were way behind on their cases, and he took a whole criminal calendar. And I was the law clerk that helped him work those cases up. And he tried a few of those cases that ended up not entering a plea. So I had some experience, at least on the federal side. Of course, the kinds of misdemeanors and different things that we saw in the state court, very different than what I experienced on the in the federal court. But yeah, it was really interesting. In Fayette State Court, we don't have a recorder's court or anything like that. So I handled not only the more serious misdemeanors, but also the traffic cases and also the ordinance violations. We handled those for some of the local jurisdictions. And So certainly that was very different from the very large, complex business litigation cases that I'd handled for most of my career.
I think it's important. You can certainly serve in an appellate level without having been a trial judge, but I would think it would serve you well having done that. You've been in the trenches in the trial level, hearing, civil and criminal matters. Do you think that helped you out at the Court of Appeals? So when you're reading these appeals and hearing them, you understand what it's like at the trial level?
Oh, for sure. Because, there's nothing like being in a courtroom, especially a state court versus a federal court. The federal courts are, much more formal, and I had, spent quite a bit of time in the federal courts, but, the state courts, things are so busy. There's so, everyone's in and out, especially state courts. Most people who unfortunately start a criminal career start in state court. And so we saw a lot of people going in and out, and I think it gives you an appreciation for the ebb and flow of how hearings take place, how trials take place. You probably know from being a trial judge, that most people think the judge just kind of sits there on the bench and just kind of rules whenever there's an objection or something to be ruled on. But you and I both know that there's a lot more to it in terms of running a courtroom and making sure things flow, and because the lawyers take their cues from you on what to do next and just how to keep things moving. And I think being in that trial court gave me an appreciation for that. So when I look at an appeal, when I look at a transcript, and I'm working on it, I can picture what's going on and maybe some of the factors that weighed into why a trial court did something a certain way. It may not be readily apparent on the record, but you can maybe discern that from having experience in the trial court.
And that's right. And, when you mentioned having to do the trench work, I had to do the same thing. One day or 1 week, you might try a medical malpractice case, or a wrongful death case that has immense importance to the litigants or parties. And then the next calendar, you might be doing traffic court with somebody getting a speeding ticket. But the way I looked at it is that, for those cases that were really low level, such as speeding tickets and traffic violations, not only are those folks not really criminals, even though that is a criminal offense technically, that may be the only experience they ever have with the judicial system. So I sort of felt it incumbent upon the trial judge that you need to make sure it's fair, and you need to make sure they get a good impression of the system when they come, because that may be the only time they've ever seen a judge or anybody or a jury in their life, and hopefully so.
Oh yeah, for sure. I think that, like I said, being in state court, that's a lot of times that's someone's only touch with the justice system, the criminal justice system, or the civil justice system, and to promote confidence in our system, we need to make sure that people are heard, they have an opportunity to be heard, that they feel like they've, even if they don't win at the end of the day, that they had a fair opportunity to make their case, and that the judge was not biased or prejudiced and decided based on the law.
The last trial I did that was, it may have been the last civil trial I did before I took senior status, and I was still on the bench full time, was a wrongful death case. And after a week-long trial, it was a defense verdict. And to say that the plaintiff's family was disappointed, that's an understatement. And when it was over, the decedent's father got up and headed toward the bench, just straight for me. And obviously the bailiff or the deputy in the courtroom went to intervene, and I could just tell he didn't mean any harm. And I said, let him come up, because he had tears in his eyes. And he said, we didn't get the result we wanted, but we got a fair trial, and that's all I could ask. And he wanted to shake my hand, And so I think it is important for judges to give, fairness and look fair in all things that they do, so that people leave even when they don't get the result they want and feel they had their day in court. So I agree with you there. Let me ask you another thing about being a judge. A lot of times folks think the grass is always greener, and I will certainly have always appreciated the time that I was on the bench full time. But even in state court, with security measures in place now, nobody could come to your chambers without being buzzed back or call ahead of time. So really your life revolved around your secretary, your court reporter, and your law clerk or staff attorney. Those are the three people that I dealt with, 90% of my day, and that was it, other than being in the courtroom. How is it at the appellate level? Is it even worse than that, or do you have a lot of interaction with folks beyond your staff?
Oh, well, no. I mean, it's even more isolating, I would say, um, because we don't have trials or hearings uh, like you do in the trial courts. So, um, I don't even get to see people most of the time. We have oral arguments maybe 1 week out of the month. And other than that, I'm just working with the other justices or my staff. I have two staff attorneys and a term clerk on the Supreme Court, as well as my judicial assistant. Um, so that's basically who I see day in and day out. So that's why I think it's really important for judges to get out in the community so that people can see us and we can see them. And whether it be participating in functions with the State Bar of Georgia or going to the Rotary Club or Kiwanis or other um, social organizations like that, I think it's important for judges to get out and interact with the community so that they can, we're accountable to the people ultimately because we're elected officials, and I think it's important that we remain a part of the community.
Well, I've seen you at more than one social function since you've been on the Court of Appeals. Quite frequently, I see you out and about. And I'll just tell you, I made a conscious note in fact, it was probably a Christmas function or a holiday function rather. Last year, I saw you and you were, I won't say working the room politically, you were working the room speaking to people. I saw you you came up and greeted me, and we hadn't seen each other in a year probably. And you were greeting everybody warmly. I personally think that's important, not only for trial judges, but even folks of your stature, because people aspire to become you one day. And if you seem aloof and distant, it's very difficult for them to get an impression or a warm one of you. But I just wanted to commend you. I think you've been fairly cognizant of doing it, and I think you're pretty successful at it. Are you received warmly when you talk to folks that you don't know that well?
I think so. I mean, I think people are interested in what I do on the Court of Appeals. When I was on the Court of Appeals, and of course, I'm sure they'll be interested to know what I do on the Supreme Court. Now, once we get out of this, coronavirus shelter in place, and I get to go out again. But yeah, I mean, I think I actually like going out and meeting people. I'm social that way, so I enjoy going and talking to people and touching base with folks that I've met over the course of my career, and just seeing what was up. And I remember that party, and I think that was when I learned that you were leaving the bench, or you just left the bench, and that you were going to go to Miles Mediation. So I know we talked about that quite a bit, and I was happy to hear that you were moving on in your career and something that you wanted to do. So yeah, I really enjoy that part of it.
It's good to catch up. Speaking of, you talked about the state we're in now. You are a justice already, but in past times, there's always a big investiture down at the Capitol, usually in the House chamber or, somewhere the rotunda or something, and everyone gets invited. And I've been to several for past colleagues that I know that get appointed to the bench or to a higher court. And I didn't get to do that for you. So tell everybody how it is you ascended to the Supreme Court in the age of the coronavirus.
Well, as you can imagine, the Supreme Court, they were ready for me to get on as soon as the announcement came out that Governor Kemp had picked me. So last week we did end up having a private ceremony so I could be sworn in and could get started working on the court. I actually have had a couple of these other swearing-ins, and the more traditional ones. One was in the House chamber when I went on the state court, and then when I went on the Court of Appeals, it was during session, so we had it out in the rotunda area. And so I've had a couple of those investitures. This one was very different. It was a private ceremony where only members of my own family who actually lived in my house were allowed to attend. So my mother and others who don't live with me were not allowed to attend. The governor's office also asked us to keep the time and place confidential because they didn't want people to appear, because I'm sure people would have wanted to come, but so we kept everything confidential, and ended up having the ceremony at outside in Liberty Plaza, which is right across the street from the Capitol, where there is plenty of space, and we just stayed 6 feet apart. In addition to me, the governor also swore in Judge Verna Colvin and Judge Trey Pipkin for the Court of Appeals. So, there were 3 groups of us waiting to be sworn in, and then the governor and his staff were in another group. And we approached when I got sworn in. I approached. We stayed probably 6 or 7 or 8 feet apart. I got sworn in. Didn't shake anybody's hands or anything like that, but. I guess that's how you do it in the age of the coronavirus. But we were fortunate that the governor's office did end up live streaming it on his Facebook feed. In this age of social media, I guess that's what you do now. And so, so it was recorded, so other people could watch if they wanted to. And but it was a very special ceremony, and I'm glad we were able to do that during this time of shelter in place. But the governor did say that once things settle down, that we would have a formal investiture like I had before.
Well, you're deserving of that honor, but I'm glad that you were able to take the oath and go ahead and get to work, because I'm sure they needed your presence to continue operations. Let me ask you this. When you got appointed, you mentioned Judge Verna Colvin, who I believe was on the Superior Court in Bibb County down in Macon. Looks like Governor Kemp has taken, diversity seriously, meaning he's made some diverse appointments. I've called you a trailblazer, and you may not have intended to that, but you were also the first Asian American on the Court of Appeals and now the Supreme Court. And there's not a whole lot of Asian American judges in the state as far as at the trial level. So do you think that's important for the appellate courts and trial courts to reflect the community like that?
Oh, sure. Like I said before, our justice system works because the public has confidence in it. I mean, if the public didn't have confidence in it, then, how are we going to get jurors in? How do we get people to, follow our rules and procedures? I mean, it's all built on, trust that you're going to get a fair trial and a fair hearing within our justice system. So I think it's important that our justice system reflect our population, whether it be gender or race or economic diversity, geography. I think it's really important. I mean, on that, a lot of people talk about me being the first Asian American on the Supreme Court, but I'm also originally from Augusta, Georgia, and so I started looking back, and the last Supreme Court justice that historians have been able to find from Augusta was actually in 1905. Justice Joseph Lamar, who ended up also serving on the U.S. Supreme Court. But Augusta's was the second largest city in the state for many years. I think they've been surpassed now, but it's kind of and one of the oldest cities in the state, and it's interesting to me that I can provide that sort of geographic diversity for the Supreme Court as well, being originally from Augusta, and I'm proud to represent that part of the state.
Maybe you can repeat history and head on into the federal courts after your service there. You're still young enough. Which brings me to another question. You mentioned your family was allowed to come that lives with you. I know for a fact that, you value family and have been a mother while being a judge. How do you balance all that? You have a really important job. How do you balance the work-life situation?
Yeah, I mean, I think it's not easy all the time because if you're a perfectionist, you want to do everything well all at the same time. And I think some of it you just have to understand that you can have a balance, but what that means is that you can do some of the things 100% some of the time. And for instance, when I was a practicing lawyer and I had a trial, I don't think I was a very good mother. In fact, I know it wasn't because I wasn't even here. I'd be other state trying a case, so my husband had to take everything up. But when I'm here, I do focus on the kids, and of course now I spend 24/7 with them, so they're probably tired of being with me. But just
homeschool teacher.
yeah, but you just do what you can and just try to not only make time for your kids, but also make time for yourself, because you can't be a good mom, you can't be a good judge if you don't take care of yourself, your physical and mental well-being. So I do try to take out time for activities that I enjoy that are stress relievers, and such as exercising or hobbies and things like that.
You've been a judge, and I have found that many judges, their children are all grown, and so that they don't have quite the work-life balance worry that some of us do. But many of us have children still at home. I still do. But you're correct. If you're a practicing lawyer, you have a lot more worries, and you work a lot more nights. That may be taken away from your family. So you could be right about that. That could be a benefit of being a judge. Do you find it important to turn it off when you go home, though, and stop worrying about what cases you may have pending?
I try to, but there are certain times when um, there's a big case, and you definitely worry about it, especially as a trial judge. I mean, even though um, we were at state court, we were only dealing with misdemeanors. You say only misdemeanor, but I mean, you give someone a year, you take a year of their life away, send them to jail. I mean, that's a big deal. And so you struggle with things like that. I mean, now I have to say, in the pandemic, and you're working from home, it's really hard to turn it off because you basically can work like all day and all night. Like your office is right here. So, and it looks like I'm in the courtroom. I'm on a Zoom with the courtroom in the background, but it looks like I'm in the courtroom, but I'm not. I'm just sitting, with steps away from where my children's rooms are, and the kitchen, and just go and take a break, and I come right back to work, and it's easy to do that.
You've brought us to something that I wanted to ask you about, and that is any crystal ball. Do you have any idea how long the judicial emergency or the Chief Justice's order is going to remain in effect, do you think? And do you think the state legal community is adapting well to the confines we have?
Well, currently the Chief Justice's emergency order goes to May 13th. So we still have a little bit of time under the current order. So no idea whether that's going to have to be extended or not. But I do know that the Chief Justice has been meeting regularly with the Judicial Council. I think up until this week, they've had weekly meetings. I don't think they're going to have a weekly meeting next week because they're actually having a Judicial Council meeting on Friday. But the Chief Justice has been getting input from all classes of courts on how to keep all essential functions going during this time. And then, of course, then that begs the question, what is an essential function and what's a non-essential function? And then there are certain functions that are considered non-essential, maybe, a civil case that could sit, but then again, maybe the lawyers want to keep things moving, and so the Chief Justice and the members of the Supreme Court have done things to make it easier for lawyers to continue with civil cases, such as allowing for video depositions, and there was some relief related to real estate filings and such. And recently, actually this morning, the Supreme Court issued an order putting off the bar exam from July to September. And then also at the same time, provisionally admitting those lawyers or those law students and would-be lawyers who would have been taking the bar exam, and maybe they have jobs lined up and they need to work. And so that order allows them to do that provisionally until we have a bar exam that they can take. And so I think the Supreme Court's done a really good job. Our Chief Justice has done a really good job trying to keep the courts going, the essential functions of the court going, while at the same time, keeping everybody safe. And also, there's been a lot of talk about, how do we come back from this? There's going to be a backlog. So what can we do now to make sure that there's not going to be a huge backlog? And so, we're thinking about all those things. And so, can't predict when we're going to be able to get back to normal. But, hopefully it'll be sooner rather than later.
Well, I have found on the civil side, obviously, where I work now at Miles, we don't handle criminal matters. They're civil matters. But you and I are speaking by Zoom now. We've just continued operations, and it looks like that lawyers and litigants are willing to participate by Zoom, and we've continued mediating just in a different platform. Instead of in person, we're doing it by Zoom, and continuing to hopefully resolve cases that way. And, me being part of the listserv, seeing judicial emails about, the trial court's response to this, it does look like there might be a backlog for the sheer fact that nothing's being tried right now. You can't call juries in, and it's very difficult to have criminal or civil calendars where people come into the courtroom. Do you think things like Zoom, which would allow for, in a court setting, you could have those certainly criminal bond hearings and things that are emergencies. You couldn't have a trial, but do you think Zoom, which allows us to do mediations and arbitrations and things like that, do you think that the technology is helpful in keeping us moving till we get back out of this crunch?
Oh, I think so, definitely. And I think a lot of the trial courts have embraced Zoom for maybe not having trials on Zoom, but hearings and different things like that, where you have to. I think, for instance, I think in a lot of magistrate courts, and they already did this before, but having bond hearings through Skype or Zoom or something like that. I think that's really important to leverage the technology so that we don't get a backlog. And in fact, the Supreme Court's having virtual oral arguments next week for the first time ever. And so we'll see how that works. But yeah, so we're going to, the Chief Justice will actually be sitting in the courtroom because in Georgia we have open court. So the courtroom is open, but to anyone who would like to attend, but we don't necessarily advise you to attend under the shelter-in-place order. But the Chief Justice will be in the courtroom, and then all of the rest of us will be at our homes, Zooming in, as well as the attorneys who will be Zooming in and making their arguments. So those arguments are going to be live streamed, so the members of the public can watch if they would like. But I think that certainly we hope that it works well next week. We've tested the technology and I think it will work. So we'll see.
Well, it looks like it's working so far. My opinion is it might be working so well that even when the crisis is over, people still will use technology that they never used prior because of the way it is working, I think.
It would have been very helpful when I was in private practice. Of course, back then they didn't have Zoom or anything like that. I mean, it's been over 10 years, but, you have a hearing that's maybe like a status conference in another town or state. Sure, it would have been very helpful for me and, less expensive for the client for me to just Zoom in, just tell the judge, okay, we're still in the middle of discovery. We're still not going to be able to, we're not going to finish until, it'll take us, another 6 months and ask for an extension of time. I mean, to, spend a day traveling to tell that to the judge when you can Zoom in, I think is not efficient. So hopefully judges will start using that more to make things run more smoothly, and also save everyone time and money.
Well, I don't profess to be an expert on Zoom by any means, but I was privileged in that I've taught for Mercer for several years now, and my courses that sometimes use Zoom, so we can have a Zoom meeting without coming to the classroom. So I already had I was proficient in it enough to use it and have those meetings. And then when this shutdown occurred, obviously I brushed up on it even more so I could mediate and arbitrate that way. But it's funny watching these lawyers and judges that you would not think would ever be technologically savvy, and they've come on board really quickly, I've found. I don't know if you've had experience with that, but it looks like people are learning really quickly. Did you already know all this technology, or did you have to learn?
I think I'd been on a Zoom call maybe once. I didn't use it on a regular basis, but I feel like maybe because I'm on several boards, and from time to time we'll have to have a virtual meeting, or people will call in, and I think they've used Zoom for that, or some other platform. But yeah, I have really had to get up to speed on Zooming, especially in a more professional environment. Not like setting up with your phone somewhere and just having a meeting. But setting up in your office so that you have everything that you can to work and have a productive meeting.
Folks will be listening to this podcast by audio, but you and I are recording it via Zoom, and I mean it literally looks like you are sitting in the courtroom, the Supreme Court. I mean, it looks like the Supreme Court bench is behind you. So you're getting technologically savvy. I don't know if you have a green screen or if your just computer is generating that behind you, but it looks like that's where you are. And I don't have those. I don't have that with me at the moment, but it is impressive. We've had meetings by Zoom that it looks like folks are on the beach and they're sitting in their living room. I don't know if you saw the article this week that a judge had to admonish litigants. One of them was at the beach and didn't have a shirt on, one of the attorneys.
I saw that. I mean, we actually put on our oral argument calendar notice that business attire is required. So lawyers are on notice that they can't show up to Zoom without being dressed appropriately. But I have to credit our IT department. They're the ones who set me up with all of this. In fact, I in this day and age, I didn't know how I was going to be able to work from home and transition. But it's really been seamless. The IT department at the Supreme Court has set me up with a home office, basically. So I have my computer. I have other screens that I can use. I have a printer. So we've conducted bank meetings by Zoom. And I've worked on opinions. I've done everything here that I could do in the office. And it's really a credit to our IT people who've really set me up. And then also my husband, who helped me set the computers up, because I didn't know how to plug everything together, but it's all set up now.
Well, that's good. Well, before our time's up today, there's two areas I want to go over with you that I think is really important. The first of which is, you were mentioning about the holiday parties that we were at not too long ago before this shutdown stopped socializing. And this may have been at the Lawyers Club holiday party, but the president of the Stonewall Bar Association, his name's Barrett Broussard, he and I were talking about diversification of the bench. And basically, the question is, what is the best path for any person in the bar who wants to join the judiciary? And you've been really successful. Not only did you make partner at a prominent law firm, you've been a trial judge, an appellate judge, you've made it to the Supreme Court. What advice would you give to anyone who aspires to be a judge? And you know as well as I do, there are folks going to law school who don't have connections. They don't come from a very wealthy background. You mentioned economic diversity and geographic diversity. What would you tell those folks? How would you approach it if you were aspiring to be a judge?
Well, first of all, I think to be a judge, you need to be the best lawyer that you can be in your practice area. And to be a judge, you probably ought to be a trial lawyer or in litigation. I think that if that's what you aspire to, we don't have many former corporate lawyers on the bench. And so I would, that's number one, just be the best lawyer that you can possibly be. And then, frankly, being a judge, a lot of it's based on the circumstances at the time. I never planned on being a judge. It just that an opportunity arose where I was able to apply with the JNC, and I ended up getting the position. But I was in this position because, again, I'd been successful as a lawyer, but also I think I was in the right place at the right time, and also was in a community where frankly, there's not as many lawyers, because in Atlanta, I think, there's tens of thousands of lawyers that practice in Fulton County. And it's very difficult to make yourself stand out versus, I'm in Fayette County and the bar is much, much smaller. And, being a judge here, you have to live in the county or the circuit where you're going to be a judge. So I tell a lot of young lawyers, especially young, diverse lawyers, to don't be afraid to be a big fish in a small pond. I know everybody wants to go to Atlanta, and maybe that's because you have a lot of friends there or people who look like you there, but don't be afraid to go out somewhere else where you can be very, very successful and make yourself stand out. I point to Judge Ming Lim, who's in the Patala Circuit. Bremen. He's the first Asian American Superior Court judge here in Georgia, and he won through an election.
I remember that.
I think that the population is less than 5%, 4%, 3% Asian there. It's just not very diverse. And so, but he did a great job in his community and ended up winning that election. So, that's the number one advice I give to people. Just be the best lawyer you can be, and then try to find. If you can live somewhere where it's a little bit less of a competition, fewer lawyers to compete with, if you want to become a judge, I think that's also helpful. Don't be afraid to do that.
That's good advice. I never thought about. So many lawyers are in Atlanta that it would be much harder to stand out than in one of the more rural areas, or in the metro counties where you and I lived. The bar is much smaller, so I think that's sage advice. Now then, the last area I want to go over, which will have some significance and importance to folks listening, whether they want to be a judge or not. When I was a trial judge, I had one mortal fear, and the other judges told me I needed to get over it, and that was I did not want to get overturned on appeal. I don't know why. I just that the thought of being overturned on appeal, I don't know if it meant you didn't know what you were doing, or you denied somebody the relief they should have received. But it wasn't until my final year in office, and I served 10 years full time or a little bit more, that I was reversed by the Court of Appeals. I don't think you were on the panel though, Carla. And so I was just downtrodden. No, the case is going to have to be tried, but a new judge will try it. And then the Supreme Court unanimously reinstated and said I was correct. The Court of Appeals was wrong. So I came out with some vindication there. But as a lawyer, you are, a lot of folks that I deal with at Miles, one of the considerations in mediation is if we go to trial and achieve a verdict, will it be appealed? How long will it take to get through the appeals process? What is the likelihood of success? You've been an appellate judge, about to serve on the Supreme Court, which is arguably even more important, even though you probably hear a smaller number of cases than the Court of Appeals. For those lawyers who find their way to the Court of Appeals and Supreme Court, what advice do you give them? Not everybody files appeals on a daily basis. They may only find themselves there once every blue moon. What do you look for in a lawyer? What do you look for in the pleadings? Are there errors people make, or how would you advise them?
Well, I think the first piece of advice I give to any lawyer who has an appeal is to read our rules, whether it's the Court of Appeals rules or the Supreme Court rules. And even if you've had an appeal before, read our rules because we change them and amend them all the time. And the rules will give you a lot of guidance on what the standards are, and also how to set up your briefs. And sometimes we dismiss things for not complying with our rules. So just first of all, read our rules. And then as far as briefing, what I tell lawyers, if you're the appellant, is try to get a second set of eyes, especially if you were the trial lawyer on the case, because you were so involved in the case. And every time the judge ruled against you, or every time you thought that the trial judge made a mistake, you were upset by it. However, not all of those mistakes are reversible error. So I encourage people to have another set of eyes so that you can discern what is the reversible errors in the case that you can bring up, because our briefs are limited in pages, and it's very, very difficult to brief 10 enumerations of error well. It's almost impossible. And so try to cull it down to your top maybe 3 errors, possibly 4. So that's what I would mainly encourage lawyers to do. And then finally, I know a lot of people want to ask about oral argument. At least in the Court of Appeals, the court is not able to grant oral argument in most cases because there's so many cases. And then the Supreme Court, they do grant oral argument more frequently, and there's some cases where there's automatic oral argument, like the cert cases that are granted certs. But the Supreme Court has gone to a rule now where you have to request an oral argument and give a reason why you want oral argument, why you need oral argument. So, and there's a standard in the rules on when the court's going to grant oral argument. So I tell the lawyers, if you want oral argument, make sure you follow the rules and make your case for oral argument, and just don't say, oh, it's really a complex case, so we need oral argument. Well, frankly, by the time you get to the Supreme Court, most cases are very complex. So you got to give us a little bit more why oral argument is needed.
Well, I never was an appellate lawyer. Other folks in my firm would do that, and I just passed the work to them. It's almost like going to a doctor. You want to go to a doctor that's of the specialty that you need. And so I always felt that, appealing a case, we want to make sure it's done correctly. Carla, the last thing I want to ask you about, and that is, alternative dispute resolution. I stepped down from full-time service and took senior status to do ADR, which is what I did prior to joining the bench. Over your practice as a lawyer and even as a judge, just in general, do you think ADR is something that benefits the legal community as far as, mediation and arbitration and things like that? Does it help clear backlogs, or what's your thoughts on that? Did you participate in it as a lawyer? Oh,
yes, I did. Had lots of mediations, probably fewer arbitrations because it was just not my area. My area of the law, we didn't have a lot of arbitrations, but lots of mediations. And I think it was very, very helpful to try to resolve issues. And, as a trial judge, I did try to send people to mediation. And sometimes it was successful or sometimes not. But, I did feel like a lot of times, especially if we had a lot of pro se parties in state court, and a lot of times people just want to be heard. They just want to say their piece and have someone listen to them. And so I've seen a lot of cases where I thought that it might be beneficial to actually have the parties talk to each other and try to mediate. And so, yes, I think it's very helpful. And I mediated some cases myself when I was on the state court bench.
When I was on the trial court bench, I don't know if you ever had it, but you'd have litigants, the attorneys rather, would want to come in chambers and speak to you privately for a moment about some issue. And they'd be arguing over, maybe it was a discovery issue or something, and you sat there, and as they argued among themselves and heard themselves out, suddenly the issue is resolved. Do you find a lot of times just having people talk like that can help work things out without the judge having to get involved?
Oh yeah, for sure. I mean that's why we have a meet and confer requirement for discovery disputes before they come to the judge, because most of the time people can work stuff like that out, and sometimes they need a nudge from the judge. I do remember several cases where, and I learned this from I guess a federal court experience where, and these were mainly handled by the federal magistrates. I'd have a case in district court, but the magistrates would handle discovery, and they would be basically on call anytime you had a discovery issue. You could just call them up. And so, I made myself available in a lot of, some cases where there's some contentious discovery, and I felt like that was very helpful, especially when, at some point I would say, well, if you can't decide on, this issue with deposition, why don't we have the deposition here in the courthouse? And so whenever you have a problem, I can just pop in and just resolve it. And then all of a sudden the lawyers were like, oh no, we don't need to go all the way to the courthouse and have a deposition there with the judge breathing down our necks. We can just work things out.
That helps solve the problem, even the offer to do that or the threat to do that. Well, Carla, it has been a pleasure talking to you today. There's very few people as deserving to be where you are as you. You've certainly earned the right and privilege to serve on the Supreme Court, and we all look forward to your tenure there. I appreciate you taking the time to speak with us today.
Well, thank you. Thank you for having me. Again, we're in the middle of this pandemic, so it's been a nice break to be able to catch up with you and talk a little bit about my life and career.
Well, hopefully when this is over, you'll be back on the social circuit, as will I, and we'll see one another again.
Yes, absolutely.
All right. Thank you, Carla.
All right. Thanks.
You've been listening to The Future of Resolution, the podcast. You can follow The Future of Resolution on Miles Mediation and Arbitration's Instagram, Twitter, and Facebook. If you